Almighty God, we stand in your holy presence as our supreme judge. We humbly beseech you to bless and inspire us so that what we think, say, and do will be in accordance with your will. Enlighten our minds, strengthen our spirit, and fill our hearts with fraternal love, wisdom, and understanding, so that we can be effective channels of truth, justice, and peace. In our proceedings today, guide us in the path of righteousness for the fulfillment of your greater glory. Amen. Almighty God, we stand in your holy presence as our supreme judge. We humbly beseech you to bless and inspire us so that what we think, say, and do will be in accordance with your will. Enlighten our minds, strengthen our spirit, and fill our hearts with fraternal love, wisdom, and understanding, so that we can be effective channels of truth, justice, and peace. In our proceedings today, guide us in the path of righteousness for the fulfillment of your greater glory. Amen. Almighty God, we stand in your holy presence as our supreme judge. We humbly beseech you to bless and inspire us so that what we think, say, and do will be in accordance with your will. Enlighten our minds, strengthen our spirit, and fill our hearts with fraternal love, wisdom, and understanding, so that we can be effective channels of truth, justice, and peace. In our proceedings today, guide us in the path of righteousness for the fulfillment of your greater glory. Amen. Almighty God, we stand in your holy presence as our supreme judge. We humbly beseech you to bless and inspire us so that what we think, say, and do will be in accordance with your will. Enlighten our minds, strengthen our spirit, and fill our hearts with fraternal love, wisdom, and understanding, so that we can be effective channels of truth, justice, and peace. In our proceedings today, guide us in the path of righteousness for the fulfillment of your greater glory. Amen. Almighty God, we stand in your holy presence as our supreme judge. We humbly beseech you to bless and inspire us so that what we think, say, and do will be in accordance with your will. Enlighten our minds, strengthen our spirit, and fill our hearts with fraternal love, wisdom, and understanding, so that we can be effective channels of truth, justice, and peace. In our proceedings today, guide us in the path of righteousness for the fulfillment of your greater glory. Amen. Almighty God, we stand in your holy presence
Court of the Philippines. Hear ye, hear ye, hear ye. All persons having business before the Honorable Supreme Court of the Philippines shall give their attention, for the court is now in session.
Please remain standing.
Almighty God, so that we can be effective channels of truth, justice, and peace.
you to bless and
In our
inspire
proceedings
us,
today,
so that what we
guide
think,
us in the path
say,
of
and
righteousness
do will be in
for the
accordance with
fulfillment
your will.
of your greater glory.
Enlighten our minds, strengthen our spirit, and fill our hearts with fraternal love, wisdom, and understanding, so that we can be effective channels of truth, justice, and peace. In our proceedings today, guide us in the path of righteousness for the fulfillment of your greater glory. Amen.
You may now be seated.
Call the cases.
This is a continuation of the oral argument for the petitions for certiorari and mandamus in GR number 238875, Senators Francis Kiko Pangilinan, Franklin M. Drilon et al. Versus Alan Peter Cayetano, Salvador Medialdea et al. And case GR number 239483, entitled Philippine Coalition for the International Criminal Court, Loretta Ann Rosales et al. Versus Office of the Executive Secretary, represented by Honorable Salvador Medialdea et al. And these cases were recently consolidated with a new one, case GR number 240954, entitled Integrated Bar of the Philippines versus Office of the Executive Secretary, represented by Honorable Salvador Medialdea, the Department of Foreign Affairs, represented by Honorable Alan Peter Cayetano, and the Permanent Mission of the Republic of the Philippines to the United Nations, represented by Honorable Teodoro Locsin, Jr. Your Honors.
Appearances.
Good afternoon, Your Honors. Pangilinan chairs for appearing for petitioner Senators Francis Pangilinan, Franklin Drilon, Paulo Aquino, Layo M. Lima, Chris Antiveros, and Anthony Villan.
Good afternoon, Your Honors. Tony Lopez for the Philippine Coalition for International Criminal Court in chair number 3948. Your Honors, Parliament, please.
Good afternoon, Your Honor. Ray Paulo J. Santiago for petitioners in GR number 239483.
Good afternoon, Your Honors. Attorney Gilbert Teruel Andres for petitioners PCICC et al. Your Honor.
Good afternoon, Your Honor. I'm Solicitor General Jose Calida for the respondents, assisted with my Assistant Solicitor Generals, Renan Ramos, Rex Bernardo Pascual, Shelo Rondain, Ana Solomon, Raymond Rigodon, and Hazel Acantilado, Your Honors.
Attorney Gutierrez.
Your Honors, we would like to respectfully
You
manifest.
may now sit down, please.
We would like to respectfully manifest, Your Honors, that last August 29, we entered our formal appearance as counsel for petitioner senators. And subject to the pleasure and approval of this honorable court, we are ready to participate in this afternoon's oral arguments, Your Honors.
Are you ready to make your presentation?
Yes, Your Honor.
So we're giving you 15 minutes to do that.
Thank you, Your Honor.
After your presentation, we will have the interpellation from the court, and after that, Solicitor General Calida will make his presentation.
If it please the court, Your Honors, before I go into our presentation, I would just like to manifest that the lead petitioner, Senator Francis Pangilinan, is present in court this afternoon, Your Honor. Okay. I will now proceed with our presentation, Your Honors. This case is not about taking power away from the President. That is conceded. He has the power to withdraw from a treaty, but not unilaterally, not without Senate concurrence, not without the checks and balances that were intended to make sure he does not act despotically, tyrannically, and beyond any form of accountability. Petitioners respectfully submit that it is for this honorable court to rule that without this concurrence, the President acted with grave abuse of discretion amounting to lack or excess of jurisdiction when he unilaterally withdrew from the ICC. Discussion of the issues assigned to the petitioner senators. First, the issue of political question. These petitions do not raise political questions. They pose solely legal issues, primarily whether or not the President committed grave abuse of discretion amounting to lack or excess of jurisdiction when he unilaterally withdrew from the ICC. This case does not question the wisdom of the withdrawal. Precisely, these petitions were filed in order that said question be submitted to the proper forum, that is, the Senate of the Philippines. The OSG superficially attempts to frame the issue as if it was the wisdom of the withdrawal that is being questioned before this honorable court. It is not. In fact, even the OSG's comment supports the justiciability of the issues before this honorable court. First, it admits that withdrawing from the treaty is merely tacitly an executive function. This concedes that the Constitution does not explicitly make the power to withdraw from a treaty solely and exclusively the purview of the Chief Executive. Absent, therefore, is a textually demonstrable constitutional commitment of the issue to a coordinate political department, which negates the claim of a political question. Second, the OSG also poses its own constitutional questions, joining with those posed by the petitioners, thus belying its claim that the issues are political in nature. It asks this honorable court, first, not to look at the constitutional provision as a limit on executive power, but rather as a limit on legislative power. And second, to find that the petitioner senators breached the principle of separation of powers when they allegedly usurp powers clearly vested in the executive. What it asks the Supreme Court to do, therefore, is to interpret the Constitution in favor of the executive's own interpretation and to allot constitutional boundaries between the executive and the Senate. Interpretation of the Constitution and this allotment of constitutional boundaries is undeniably the domain of the judiciary. The OSG thus concedes that the issue before this honorable court is justiciable and not a political question. Second issue, that certiorari and mandamus are proper remedies. It is well settled the exercise of the power of judicial review under the Constitution can be initiated through a Rule 65 petition for certiorari. In Araulo versus Aquino, this court reiterated that petitions for certiorari and prohibition are appropriate remedies to raise constitutional issues and to review and/or prohibit or nullify the acts of legislative and executive officials. Araulo states that with respect to the honorable court, the remedy of certiorari is broader in scope and reach, and thus may be issued to correct errors of jurisdiction and undo any act of grave abuse of discretion by any branch or instrumentality of the government, even if the latter does not exercise judicial, quasi-judicial, or ministerial functions. The instant petitions assail the act of the President of withdrawing from the Rome Statute without the concurrence of the Senate by a 2/3 qualified majority vote. This unilateral act of withdrawal is an unconstitutional act and was thus committed with grave abuse of discretion. It is therefore subject to the power of judicial review of the Honorable Court via certiorari. On the other hand, mandamus is the proper remedy to compel the executive to revoke the note verbal submitted to the UN Secretary General withdrawing the Philippines from the Rome Statute. Mandamus is the proper remedy in cases where there is grave abuse of discretion, manifest injustice, or palpable excess of authority. Third issue, that petitioner senators have standing. The standing of members of Congress in a petition assailing the validity of any action which infringes on the powers of Congress is well settled in jurisprudence. This has been the ruling in Francisco versus HRET and Biraugo versus Truth Commission, cited by the OSG itself. In Pimentel versus Executive Secretary, The Honorable Court ruled that to the extent the powers of Congress are impaired, so is the power of each member thereof, since his office confers a right to participate in the exercise of the powers of the institution. Thus, legislators have the standing to maintain inviolate the prerogatives, powers, and privileges vested by the Constitution in their office and are allowed to sue, to question the validity of any official action which they claim infringes their prerogatives as legislators. In the instant petition, the President has infringed on the Senate's treaty powers. Any senator, therefore, has standing to challenge this infringement before the courts. Fourth issue, the treaty withdrawal demands Senate concurrence. As much as the OSG wants to claim that treaty withdrawal is the exclusive prerogative of the President, there are compelling grounds for rejecting this view. First, variances in the text of the Philippine constitutions on treaty-making powers clearly indicate an intention to make treaty-making a shared power between the President and the Senate. The 1935 version echoes that of the US. It starts with a grant of power in favor of the President to make treaties subject to the concurrence of 2/3 of all members of the Senate. Please refer to the slide. In contrast, the 1973 Constitution is where despotism and tyranny rear their ugly heads. It did away with any limitation and simply makes a plenary grant of discretionary power, as can be seen in the slide. The 1987 Constitution abhors not just concentration of power, but despotic and tyrannical exercise of power. Hence, the language employed in the 1987 Constitution, which is emphatically prohibitive. As the slide there states, Article 7, Section 21, no treaty or international agreement shall be valid and effective unless concurred in by at least 2/3 of all the members of the Senate. This is mirrored in the transitory provisions under Article 18, which reiterates the same principles, Your Honor. In contrast to the pre-martial law formulation, there is no positive plenary grant of the treaty-making power to the President. This is a clear and unmistakable manifestation of the intent to withhold from the executive any monopoly over the power of treaty-making. The intention is to make treaty-making a joint power of the executive and the legislative. The intent is to prevent any unilateral exercise of power in relation to treaties. That is with regards to treaty-making. What about treaty abrogation and withdrawal? Nowhere in the Constitution does it say that the President has the sole exclusive authority to withdraw the Philippines from a treaty, much less withdraw unilaterally therefrom without Senate concurrence. It cannot be automatically implied that just because treaty withdrawal involves foreign relations, it is solely an executive prerogative. In the first place, the Constitution has explicitly provided certain matters on foreign relations as also the province of Congress, and therefore are not exclusive to the President, such as treaty-making itself under Article 7, Section 21. On the other hand, to conclude that it is a joint power, one just needs to look at Section 21 of Article 7, and from the explicit intent to make treaty-making a shared power, infer on the basis of the necessary and proper doctrine of implied powers that the power to unmake treaties is likewise joint as well. Since the treaty-making power is shared between the President and the Senate, by implication, the power to terminate treaties must also be a shared power of the President and the Senate. Second, the requirement for Senate concurrence in the withdrawal of treaties is more persuasive when seen within the context of the Republican principles of checks and balances and the separation of powers between the three great branches of government. Our democratic and Republican form of government relies on these principles to guarantee that sovereignty continues to reside in the people and their elected representatives and is never concentrated in the hands of one person. Our hard-won lessons under the dictatorship led to the establishment of these guarantees under the Constitution. Justice Brion in IPAP versus Ochoa stated that the separation of powers of the three branches of government operates hand-in-hand with arrangements that allow the participation of one branch in another branch's action under the system of checks and balances that the Constitution itself provides. Moreover, that the Constitution in fact imposes such joint action so that one branch can check and balance the actions of the other to ensure public accountability and guard against the tyrannical concentration of power. The whole purpose of these Republican principles is therefore applied to the constitutional provision on the shared treaty powers of the President and the Senate. The rationale for dividing treaty-making power into two phases, involving the executive and the legislature, is because of this conscious effort to enable check and balance mechanisms in our Republican system of government. In sum, as stated by Justice Brion in his concurring opinion in IPAP, the act of entering into international agreements operates under this wider context of separation of powers and checks and balances among the three branches of government. Third, in many jurisdictions, including ours, treaties have the legal status of laws. Under the Constitution, the Senate's participation necessarily leads to the application of the doctrine of transformation. A treaty is elevated to the same constitutional rank as a law and would be secured by the same guarantee of fidelity and permanence as any other law. Since a treaty is part of the law of the land, it may be repealed or set aside only as other laws are repealed by an act of Congress or at least by a two-thirds vote of the Senate concurring with the executive. The benefits of legislative deliberations in the passage of laws applies with equal force in entering into and withdrawing from treaties. Treaties must therefore require legislative approval prior to withdrawal. The decision to exit treaties may affect legal rights and obligations in much the same way as the repeal or modification of a domestic statute does. In the instant case, the Rome Statute has a significant domestic legal effect. Our being a state party to the Rome Statute has provided our citizens recourse to the ICC to allow the President to withdraw from the Rome Statute unilaterally and without justifiable basis would impair existing rights available to citizens of state parties which are currently enjoyed by Filipinos. Fourth, the Honorable Court held in Bayan Muna versus Romulo that an executive agreement cannot be used to amend a treaty that under the Constitution is the product of the ratifying acts of the executive and the Senate. If a treaty cannot be amended by a unilateral act of the executive, so must the same be true for the graver act of repealing it completely. In the hierarchy of legislative acts affecting the efficacy of laws, repeal and abrogation are certainly in a much higher degree than a mere amendment or modification. If the President cannot amend or modify a treaty by his unilateral act of entering into an executive agreement, much less can he be allowed to repeal or abrogate one through a unilateral withdrawal without the concurrence of the Senate. Fifth and final issue, that the Philippines' withdrawal from the Rome Statute places the Philippines in breach of its obligations under international law. The Philippines, under the current administration, committed a breach of international law when it withdrew from the Rome Statute by violating the principle of pacta sunt servanda as provided for in Article 26 of the Vienna Convention on the Law of Treaties. This provides that every treaty in force is binding upon the parties to it and must be performed by them in good faith. The international law principle of pacta sunt servanda, as formalized in the Vienna Convention, is recognized under our jurisdiction. In Secretary of Justice versus Lancion, the court said, the rule of pacta sunt servanda, one of the oldest and most fundamental maxims of international law, requires the parties to a treaty to keep their agreement therein in good faith. The observance of our country's legal duties under a treaty is also compelled by Section 2, Article 2 of the Constitution. In Pimentel versus Executive Secretary, the court said that the refusal to ratify a treaty must be based on substantial grounds and not on superficial or whimsical reasons. As it is for the refusal to ratify, withdrawal from a treaty that constitutes a repudiation of a state's obligations under such treaty must likewise be based on substantial grounds and not on superficial or whimsical reasons. The reasons for withdrawal mentioned by the President, however, can easily be construed as being purely personal to him. He said, given the baseless, unprecedented, and outrageous attacks on my person, as well as against my administration, engineered by the officials of the UN, as well as the attempt by the ICC Special Prosecutor to place my person within the jurisdiction of the ICC, I therefore declare and forthwith give notice as President of the Republic of the Philippines that the Philippines is withdrawing its ratification of the Rome Statute effective immediately. The repudiation of a treaty because of reasons personal to a head of state cannot unfortunately be considered as performance in good faith under international law. States enter into treaties with the expectation that other parties do so in good faith and as a matter of deliberate, rational, reliable, and stable national policy considerations. It is to guard against precisely this type of whimsical action that Senate concurrence in treaty withdrawal must be required. In Lacoste versus Fernandez, the court had the occasion to characterize the state's obligation to faithfully abide by the treaties as non-personal commitments and one that transcends incumbent officials or administrations. The court said that a treaty or convention is not a mere moral obligation to be enforced or not at the whims of an incumbent head of a ministry. It creates a legally binding obligation on the parties founded on the generally accepted principle of international law of pacta sunt servanda, which has been adopted as part of the law of our land. And it is this need for stability anchored on good faith compliance and institutional, as opposed to individual obligation that provides one of the strongest reasons for the current constitutional design that makes the treaty power a shared power between two of the great branches of government, the executive and the legislature. It is our earnest prayer that this honorable court affirm this principle of our republican democracy. Thank you, Your Honors.
Counsel, would you mind if I ask Senator Pangilinan a few factual questions about what happened in the Senate? You can be beside him when he responds to certain questions. If His Honor is willing.
We would just like to respectfully manifest, Your Honor, that Senator Pangilinan only has a few minutes, but because he
No,
needs to go to the Senate for...
I have 3 or 4 questions only. This has some relation to Senate Resolution number 286, which I think was led by the Senate minority. May I confirm how many signatures Senate Resolution number 286 expressing the sense of the Senate regarding the requirement for concurrence for a withdrawal?
Yes, thank you, Your Honors. Good afternoon. With the permission of the court, I will respond. But before I respond, I would like to also beg the indulgence of the court that I have to...
Yes.
There is a pending major concern in the Senate this
We
afternoon
understand.
because of the arrest,
Yes.
order of arrest of a colleague. And we are supposed to go into executive session before we begin the session, precisely to discuss the matter. Having said that, Your Honors, there were 14 senators who signed this resolution, if I recall correctly. 14 senators,
Okay.
Your Honor.
And as of now, there are how many senators in the Senate? How many seats? There are
23 senators, Your
23
Honor.
senators. So 14 would constitute a majority of the
That is correct.
23. May I know if this has been tabled for discussion and approval by the Senate?
The matter was not adopted by the Senate, although 14 senators did sign the resolution. It may be adopted at some point in future time, but unfortunately, other resolutions and other pending bills had to be addressed or had to be tackled by the Senate, and therefore this was not officially acted upon.
Just to be sure, Senator, so I understand you correctly, it was rejected by the Senate?
No, it was not rejected.
It was not tabled for
It
discussion?
was not calendared for adoption, Your
So
Honor.
can we consider it, based on your rules, as a pending matter in the Senate?
Yes, it is a matter that is pending before the Senate.
Okay. Is it true that approvals now of treaties in the Senate now contain a clause which states that withdrawal shall require the concurrence of the Senate?
That is correct, Your Honors. In fact, we have ratified 17 treaties with that specific provision, Your Honor.
Now, going back to Senate Resolution 546, which ratifies the Rome Statute, is there such a clause?
In that particular Rome Statute, Your Honor, the clause is not present.
Okay, so in other words, the Senate now has started to put that clause for the past 17 treaties.
That is
But
correct.
Prior to the 17 treaties, there was no such clause.
That is correct, Your Honor.
Thank you.
Just to manifest that this is therefore the sense and a policy, or at least the position taken by the Senate with respect to treaties.
With respect to the 17 treaties, but
Well, with
Senate
respect-
Resolution 546, you agree with me, Senator, does not have that requirement.
That is correct, Your Honor. However, if we may be allowed to state that this has now become the position of the Senate in terms of treaties that it would require a concurrence of the Senate should there be any withdrawal.
But you said also that Senate Resolution 286 is still a pending matter.
That is correct, Your Honor.
Okay. Thank you, Senator.
Thank you,
Thank you
Your
for your
Honors. Again, I would like to request that I be excused because we have an ongoing session, actually an executive session, Your Honors, to discuss the matter of the order of arrest of Senator Trillanes. Thank you.
Thank
With your
you.
permission, Your Honor.
You're excused, Senator.
Maraming salamat po, Chief Justice. Maraming salamat, Your Honors. Thank you very much.
Attorney Barry. Sorry.
Yes, Your Honor.
Okay. The standing of your clients before this court, can you explain what is the basis of their standing?
Their principal basis for standing, Your Honor, is in their capacity as senators of the Republic. Since our main contention is that Article 7, Section 21 requires Senate concurrence in any withdrawal by the executive from a treaty, then their prerogatives as members of the institution to which the same withdrawal should have been submitted for concurrence are impaired, Your Honor. And so they are bringing this matter as members of the Senate.
And they have properly asserted their prerogative as part of the minority, in fact, as 14 senators in Senate Resolution 286. Am I correct?
Yes, Your Honor.
And that matter is still pending with the Senate. Am I correct?
It is currently pending with the Senate, Your Honor.
Okay. Therefore, there is a forum that your clients have gone to request that there be a formal assertion by the constitutional body involved, correct?
Yes, Your Honor.
Yes. And while that Senate resolution is pending, you filed this petition for certiorari prohibition and
Certiorari
mandamus.
and mandamus, yeah.
And
Yes, Your Honor.
mandamus, correct?
Yes, Your Honor.
So there is a pending issue in the Senate and you filed this petition, correct?
Yes, Your Honor.
Yes. And for you, that it is mature enough for this court to take jurisdiction?
Yes, Your Honor, considering that the issue pending with the Senate is a somewhat different issue, Your Honor. That resolution is simply to express the sense of the Senate as to how the Constitution, particularly Article 7, Section 21, should be interpreted. But we are going before this court, Your Honor, to get a definitive ruling on the constitutionality and to challenge a specific act already performed by the executive.
This is my difficulty. The Senate resolution is signed by majority of the senators,
Yes, Your Honor.
yet it cannot pass the Senate.
Well, it has not passed the Senate, Your Honor, because of the procedure being followed in terms
In other
of
words, there
resolution.
is a resolution with 14 signatures, a clear majority of the 23 because there is one vacancy in the Senate. And by the rules of the Senate, it is always by majority rule, correct?
Yes, Your Honor, subject to
spite
the
of
rules
that-
of
In spite
procedure.
of that, it is pending. You come here before the Supreme Court to assert a right which has not yet been decided upon by the Senate body.
With respect, Your Honor, I believe that the fact that the Senate has already started to include, and in fact, it included as early as December 2016 in its resolutions concurring with various treaties, an explicit requirement that two-thirds vote of concurrence to the withdrawal of a treaty already expresses the sense of the Senate, and that
Which 14 have asserted in a Senate resolution which has not yet been approved by the Senate, yet you ask this court to come. You see, both parties are asserting separation of powers.
yes, Your
And
Honor.
I think this includes also the separation of powers between the judiciary on the one hand and the political departments on the other. So which includes Congress as a whole, the Senate as a body, the executive as the President of the Republic, correct?
Yes,
That's
Your
separation of powers. And
Yes, Your Honor.
in a matter where there is great embarrassment that might happen, which involves the international community, no less than the international community, don't you think that this court should tread very carefully in order to be able to decide whether we can be seized of that issue? For example, that there is still a pending matter to be hurdled in the Senate, considering that 14 decided to file a resolution rather than go immediately here. But that has been, in the UK practice, tabled, pending, not really in the calendar yet, in spite of the fact that there were 14, correct?
Yes, Your Honor.
So perhaps there are other political matters that must be considered first by the Senate in order to be able to come to a decision as to what its real sense is with respect to Article 7, Section 21. And wouldn't you think that this court should defer to that? For example, the reasons for Senate concurrence can be speculated upon by this court. Correct? It's not in the Constitution.
Yes, Your Honor.
The behavior is in the Constitution, the rule is in the Constitution, but the reasons why the rule is there is not there, correct?
Yes, Your Honor.
And at times, it is better that the actual members of a particular body articulate the reasons. Because, in truth, while this court sits in final judgment of the provisions, it is not the sole reader of the Constitution. The Constitution is read by everybody, and the Constitution must be interpreted by everybody. But at the end of the day, they risk an interpretation. We cannot give an advisory opinion. We are the final arbiters. Isn't that correct?
Yes, Your Honor. Although
yes, and the becoming deference to the popular will represented in a Republican government, because we are not only a democratic, but we are also a Republican government, is that perhaps this court should start to defer to representative bodies elected by the sovereign in order to assist it in terms of this contemporary interpretation of the Constitution. Don't you think?
Well, normally we would agree, Your Honor, as a general
Normally.
rule.
So we are now under an abnormal situation?
No, abnormal in the sense, Your Honor, that there has been a clear breach of a constitutional provision here,
Your opinion
Honor.
that there is a clear breach. But the point is, even the Senate has not expressed whether there is in fact a clear breach. And you are now asking the court to express that, that opinion.
Well, the Senate, Your Honor, to our mind, has expressed its own interpretation of Article 7, Section 21 in its enactment of various provisions in the concurrences to previous treaties, Your Honor. The very fact that they now require a two-thirds majority vote of the Senate in withdrawal is a recognition that the Senate itself views that it has the power to actually concur, to render a withdrawal valid.
It has the power to express in terms of treaties that it concurs with, correct? And as far as the good senator has said, 17 treaties.
Yes, Your Honor.
But not in the concurrence to the Rome Statute, correct?
No, Your Honor.
So, in other words, there is a new policy now of the Senate.
However, Your Honor, it's a new policy only insofar as
So
it
you
has
admit
been...
that it's a new policy?
It's not a new policy, Your Honor.
But it's not in Senate Resolution number 546.
Our position, Your Honor, is that it is...
So is it not an acknowledgement that there was something amiss or that the Senate made a mistake? But it's very difficult for this court to accept that a 24-person body of eminent senators that ratified all these treaties from maybe the International Convention on Civil and Political Rights all the way to the Rome Statute, many MLAs, mutual legal assistance agreements, many investment treaties, that the Senate did not care or made a mistake in expressing that whenever there is a withdrawal, they should withdraw. Or could this court not interpret it as, well, from the 17 treaties, there is a rule by the Senate that it must concur to the withdrawal, but prior to that, it is not stated there.
Our submission, Your Honor, is that it was not a matter of mistake or oversight. I believe, Your Honor, that the Senate simply assumed that the provision in Article 7, Section 21 should have been self-explanatory. But due to recent developments, it's clear that in the absence of an explicit rule, there is the possibility that there can be assertion, as there was an assertion made here.
The senators did not predict that a treaty can be withdrawn, that participation in a treaty can be withdrawn.
No, Your Honor.
The Constitution did not predict that participation in a treaty cannot be withdrawn. That's why there is no such provision also there.
Well, That could be true, Your Honor, because historically...
You are saying that all this is an oversight.
Not an oversight, Your Honor, but
Okay.
a clear case where the implication is so clear that there was no need for an explicit rule on
Apparently,
withdrawal.
it is not. It's only clear to those that want to see it as clear, but not so clear to those that do not want to see it as clear. You see here, you have a president with all his legal advisors, including the Solicitor General, I suppose, that saw the possibility because it is not there, verba legis, and therefore did it. So, in other words, when you assert that something is clear, perhaps from your point of view, but this court cannot be biased enough to say, just because you say it's clear, that it's always clear for this court, correct?
Well, we would expect no less from the court, Your Honor. That's why we're bringing this matter before the court for ultimate adjudication.
Yes, so you agree with me that there is no such proviso for withdrawal in the Constitution?
There is no explicit proviso, yes, Your Honor.
Yes, there is or there is not. It is there or not there?
Well,
Is it there or not there?
there is no explicit text, Your Honor.
So it is not there.
Yes, Your Honor.
Yes, so there is none.
Well, there is no
You
explicit
are
text,
asking
Your Honor.
us to imply.
Our position, Your Honor, is that it is clearly implied.
It is clearly implied, but I do not see it there, or we do not see it there.
Well, that's true, Your Honor. In the same token, that there is no specific rule saying that the President can withdraw
That
unilaterally.
ratifications of treaties prior to the 17 that the good senator mentioned, there was no such requirement to the President that if you withdraw, you tell us first.
Well, there was no explicit requirement, Your Honor. But the fact that the Senate could now include the requirement presupposes that to begin with, it has the power to
So you have now
compel
a
such
treaty
concurrence.
which states that the President must ask the Senate before it withdraws, correct?
Yes, Your Honor.
Yes, you have 17 treaties.
Yes, Your Honor.
In resolution number 546, the Senate did not include that.
It was not included there
So did
explicitly,
the
Your
President
Honor.
violate anything?
I'm sorry, Your Honor?
Did the President violate anything?
Yes, Your Honor. Article 7, Section 21.
Where? Where? 7 Section 21? There is a provision there on withdrawal? I thought you said there is none.
There is no explicit provision, Your Honor, but it's our contention that it is necessarily implied from the...
Necessarily implied. What makes the necessity? What makes it inevitable that it is implied?
Because, Your Honor, in the silence of the Constitution on an explicit mode of withdrawing from the treaty, the necessary implication, therefore, Your Honor, is that in the process of withdrawing from a treaty, the same process and the same allocation of power should be followed.
Unless we follow the point of view of the other side, which is, by the way, Article 6 of the Constitution is, what is the rubric? What is the title? Article 6 of the Constitution.
That's the legislative, that's the legislature, Your Honor.
Yes. Article 7 of the Constitution is
The executive.
executive. Under Article 6 of the Constitution, legislative, are there inserted in some provisions the powers of powers of the President? For example, in the passage of law, it is not only the House and the Senate that passes, but the President also comes in, correct?
Yes, Your Honor.
To sign.
Yes, Your
Okay.
Honor.
That is what we call, we have two terms, checks and balance, correct?
Yes, Your Honor.
So that is check and balance, correct?
Yes, Your Honor.
And because it's in Article 6, it is power of the legislature, correct?
Well, generally, Your Honor, although this
Yes. So in Article 6, it says that in order for a law to become law, Congress must pass it because they have legislative powers, and that the President performs a checking on that power in Article 6, correct? By either signing on or pocket vetoing the law, correct?
Yes, Your Honor.
Yes. In fact, Article 6, Section 1 states that legislative power is vested in
in the Congress of the Philippines, Your Honor, except to such extent as may be reserved for people through direct initiative, Your Honor.
Okay, so it just says that the power to make law, legislative, okay, the power to make anything that is law is in the legislature.
Yes, Your Honor.
It's absolute, right? Well, not really. It just says except to the extent reserved to the people through the system of initiative, correct?
Yes, Your Honor.
And you have participated in that process as a member of Congress.
Yes, Your
I'm
Honor.
sorry, as a member of the House
Your
of
Honor.
Representatives, correct?
Yes, Your Honor.
Yes. So it's exclusive, right?
Yes, Your Honor.
Where is this provision on treaties found?
It's in Article 7, Your Honor.
Executive,
Yes, Your Honor.
not legislative.
No, Your Honor.
Yes. So therefore, like in Article 6, where the principal main power is legislative, this one is a power lodged with the President, correct?
We don't agree with that, Your Honor.
Mainly lodged with the President, correct?
Well, partially lodged with the President, Your Honor,
Not only
shared
partially,
with the Senate.
Okay, let's look at Article 7, Section 10, Paragraph 7 of the 1935 Constitution, which you
Yes, Your Honor.
It states that, can somebody assist counsel? Can you read the first clause?
It says, Your Honor, the President shall have the power, with the concurrence of 2/3 of all the members of the Senate, to make treaties.
Okay, so concurrence of 2/3 of all the members of the Senate is embedded as a clause.
Yes, Your Honor.
And the verb here is to make treaties.
Yes, Your Honor.
So it says the President shall have the power, with the concurrence of 2/3 of the members of the Senate, to make treaties. So there are two that make treaties, correct?
Yes, Your Honor.
That this is in the 1935 Constitution.
Yes, Your Honor.
Yes. Can you look at the 1987 Constitution, Article 7, Section 21?
It says, Your Honor, no treaty or international agreement shall be valid and effective unless concurred in by at least 2/3 of all the members of the
So
Senate.
it assumes that Senate gets it at the end, because it says to be valid and effective unless concurred in by at least 2/3 of the members of the Senate, which means the treaty is already there, the international agreement shall already be there, correct?
Not necessarily, Your Honor.
It's here, very clear. Now you're saying that it's not there.
Well, it's there, Your
No
Honor.
treaty or international agreement shall be valid and effective. So there is now a treaty there,
Yes, Your Honor.
unless concurred in by at least 2/3 of all the members of the Senate. Look at the grammatical construction of Article 7, Section 21.
Yes, Your Honor.
It does not imply that both the Senate and the President engage in the negotiation, unlike in the 35 Constitution. It says the President shall have the power with the concurrence of 2/3 of the members of the Senate, so there is more active consultation there to make treaties, correct?
Well,
You are the one that said we have to look at the text of the Constitution.
yes, Your Honor.
I am looking at it very carefully and telling myself, why is there a change in the language?
Yes, Your Honor.
Yes, and perhaps because the change in the language is to make clear that the negotiation of the treaties, the entering into its obligation, is principally under Article 7. And I look at Article 7, it says the executive, the President, correct?
That's a possible interpretation, Your
Yes,
Honor.
and therefore, concurred in by at least 2/3 of the members of the Senate is a check on the treaty-making power.
It is, Your Honor.
Yes, it is not an equal partnership. It is that the President shall determine first which treaty it wants to engage in, and then ask the Senate to concur, correct?
Well, that's
It cannot be
procedure,
that
Your
the
Honor.
Senate decides which treaty and then asks the President to sign, correct?
We accept that, Your Honor.
Yes, so it is first the President and then the Senate, correct?
Yes, Your
The
Honor.
President does not want to sign the treaty, the Senate cannot do anything, correct?
Yes, Your Honor.
Pimentel versus Executive Secretary,
Yes, Your Honor.
correct? And the Supreme Court said, we cannot force the President to transmit the signed copy of that treaty, right? Because
Your
it
Honor.
is up to the President to choose whether, in fact, it wants to complete the entire process, correct?
Yes, Your Honor.
So it is the President that decides it first.
Yes.
Yes.
We agree, Your Honor.
Okay. Now, let's go back to the 35 Constitution. Okay? 35 Constitution says, in Article 7, Section 10, it is joined with the power of the President to appoint ambassadors, correct?
Yes, Your Honor.
Okay. Just as a recall of the question of Justice Alex Esmundo last meeting, and if I may borrow from Justice Esmundo, when the President recalls an ambassador, does he have to go to the Senate?
No, Your Honor.
No. So when the President recalls a treaty, you are now saying that, well, perhaps it is necessarily implied that the Commission on Appointments must also be consulted.
Well, precisely, Your Honor, the fact that the power to concur in treaties has been separated in the 87
No,
Constitution.
in Commission on Appointments, it's still the same, correct?
Yes, Your Honor.
It's still the same, right?
Yes, Your Honor.
So therefore, by the way, where is that power of appointment lodged? Is it in Article 6 or Article 7?
It's in Article 7. Your Honor.
7, right? Okay, now, when the President makes an appointment, he has to get the confirmation of the Commission on Appointments before the ambassador is sent. Of course, they will have to get an agreement from the foreign government or foreign head of state, correct?
Yes, Your Honor.
Yes. So when they recall the ambassador, are you now saying that the Commission on Appointments must also have its say?
No, we're not, Your
Is
Honor.
it not necessarily implied because it is not there?
Well, there is a world of difference, Your Honor, between the
Yes, what
withdrawal
is that
by an
world?
ambassador and
What
the
is that
withdrawal from
world
a
of
treaty, Your
difference?
Honor. In the withdrawal of an ambassador, Your Honor, we are simply changing the official representative,
Yes.
which, to begin with, is actually acting on behalf of the Philippine government and
Yes.
is hence a representative of the President himself or
Yes.
herself. In the withdrawal from a treaty, Your Honor, it is not simply the President's representation that is at issue, but substantial rights of ordinary citizens will be affected, Your Honor.
But there is a treaty and there is a treaty. There are treaties which actually produce certain obligations of the state as a government vis-a-vis another government.
Yes, Your Honor.
There is a treaty that produces an obligation of the government vis-a-vis foreign nationals sojourning under the country, in the
Yes, Your
country.
Honor.
And there is a treaty that governs the relationship of the government vis-a-vis its own citizens as it commits to the international community,
Yes, Your
like
Honor.
human rights.
We agree,
So
Your Honor.
there are treaties that are producing certain obligations, and there are treaties which do not produce an obligation.
Well, all treaties produce obligations, Your Honor. The only difference is to whom the obligations are owed. They can be
Precisely.
to other states, to
Yes.
an international...
So in human rights, we commit to a community of nations that we are abiding by certain kinds of norms, correct?
Yes, Your Honor.
Yes. And therefore, whether that commitment is produced in a treaty or in a law, it will be the same for the citizen, correct?
Yes, Your Honor.
Yes, because if the government says, I will not commit genocide to the United Nations, but there is a law which actually says, I will not commit genocide, then that's the same, correct?
Well, insofar as that specific substantial
So when the
question is
President
concerned,
withdrew
yes.
from the Rome Statute,
I'm sorry, Your Honor.
when the President withdrew from the Rome Statute,
Yes, Your Honor.
is it now committing to commit, not respect the rule on genocide?
No, Your Honor, because there is a domestic
There is
law
a domestic law,
which
correct?
covers it. But it does deprive, Your Honor, Filipino citizens from recourse to the International
Okay.
Criminal Court.
This one I want you to cover in your memoranda, but if you can preliminarily answer now, then I would
Yes,
be
Your Honor.
glad. Does the President have the power of indirect legislation? Under Article 7, Section 21.
Only to the extent that a treaty entered into by the President and duly concurred in by
Can you
two-thirds of the
please
Senate
read
will become...
Article 6, Section 1?
Your Honor, the legislative power shall be vested in the Congress of the Philippines, which shall consist of a Senate and a House of Representatives, except to the extent reserved to the people by the provision on initiative and
Okay,
referendum.
thank you. Legislative power is vested in Congress.
Yes, Your Honor.
Yes. So here it says treaty-making power, correct?
Yes, Your Honor.
Yes, and we cannot conflate the two because there is a clear provision which lodges it very clearly on only one. We have to harmonize the provisions of the Constitution, correct?
Yes, Your Honor.
And textually and canonically, interpretations of a constitutional provision is not only verba legis, but also in the context of the four corners of the document, correct?
Yes, Your Honor.
So we cannot interpret a constitution in such a way that we expand the powers of the Senate or of the President but at the same time infringe or abridge or interrupt certain powers that are clearly lodged on one political department, correct?
We agree, Your Honor.
Yes. Okay, but again, that's my question. Is it your interpretation that the President actually has the power of indirect legislation contrary to Article 6, Section 1?
Your Honor, if the Constitution itself, in the treaty clause, provides for an alternative means by which a treaty will have the effect of a domestic law, Your Honor,
Yes.
then yes,
Well,
subject to the provision of Article 7, Section
It can
21.
have the
Your Honor.
effect of law, but it is not law, correct? It is a treaty.
It is a treaty, Your
Yes.
Honor.
If the Senate and the House wants the President to be committed to a foreign policy, then it passes a law, correct?
Yes, Your Honor.
As it did, Republic Act 9851, correct?
Yes, Your Honor.
Yes, but in 9851, it did not say that there is a court above this court, correct?
Yes, Your Honor.
Yes, and there's only one Supreme Court, and this is it, correct?
Yes, Your Honor.
Yes, and therefore, it did accept reverse complementarity, correct? Such that when the Security Council sees that there is a matter or situation in the Philippines and wants to refer it to an international criminal tribunal, then it can. Right?
Yes, Your Honor.
Yes, or when a next administration would want to make use of the powers of the International Criminal Court, it can actually do so, correct? As a non-treaty member.
It could, Your Honor.
Yes. So therefore, there is still that remedy, correct?
Yes, Your Honor,
But for this administration, it says, well, insofar as we are concerned, we are relying on the courts, correct?
Yes, Your Honor.
As there was a report that in Manila, there was somebody that was acquitted who was allegedly non-laban in a regional trial court, correct?
Yes, Your Honor.
Yes, and in terms of acquittals of drug offenders, the batting average is not so low in terms of trial courts and the Supreme Court, correct?
I would not know, Your
And
Honor.
as a matter of
unfortunately.
fact, there have been cases that reached this court where one, which I had the privilege to write, where we call the attention of the extortion or abuse of police officers, correct?
Yes, Your Honor.
Yes. So it is possible that courts can attend to certain kinds of shenanigans or abuses of power, correct?
Yes, Your Honor.
Yes. And the ICC only requires that there is inability or unwillingness, correct?
Yes, Your Honor,
Yes.
under Article 17.
Okay. IPAC versus Ochoa. What was the issue there? Was it withdrawal? You cited it.
Yes, Your Honor. No,
IPAC
no, it was
versus
not. It
Ochoa.
was not. It's not withdrawal, Your Honor.
It was whether that the Madrid Protocol was a treaty, correct?
Yes, Your Honor.
Whether it was an international agreement or a treaty, correct?
Yes, Your Honor.
And the Supreme Court was unanimous in the result, but there was a dissent, correct?
Yes, Your Honor.
And that dissent was by who?
I'm sorry, Your Honor. I don't recall.
That international agreements are likewise require the concurrence of the Senate, except that it was unclear whether this is the kind of in the international agreement that requires concurrence, correct?
Yes, Your Honor.
Yes. So it was not about withdrawal,
Yes, Your
correct?
Honor.
So it cannot be a precedent.
Well, not insofar as the withdrawal is concerned.
So
Your
whatever
Honor.
was written there by the ponencia in relation to withdrawal is obiter dictum, not ratio decidendi.
Well, I suppose, Your Honor.
Yes. While we are in Latin phrases, pacta sunt servanda.
Yes, Your Honor.
What does it mean? Can you
It's-
translate that?
It's performance in good faith of obligations, Your Honor, under international law.
Okay, pacta sunt servanda means that whatever obligations are committed, they must be followed in good faith, correct?
Yes, Your Honor.
And the obligations include whatever is in the treaty, correct?
Yes, Your Honor.
The entirety of the treaty,
Yes, Your Honor.
yes. And whatever the entirety of the treaty awards as powers or duties or rights should be respected, correct?
Yes, Your Honor.
Yes. What is Article 127 of the Rome Statute?
That is with respect to withdrawal, Your Honor.
Wait. The Rome Statute allows withdrawal by a state party.
Yes, Your Honor.
Is there a requirement for why the party withdraws?
Well, no, Your Honor.
None. Okay. So when a state party withdraws from the Rome Statute, it is a violation of pacta sunt servanda because there is Article 127 of that treaty. Or is that illogical?
It is not the withdrawal per se, Your Honor, that constitutes the violation of pacta
What
sunt
is the
servanda.
violation of the pacta sunt servanda?
As we argue, Your Honor, it is rather than the simple fact of withdrawal, it is the reasons given for the withdrawal, Your Honor.
The reasons. But you just said that pacta sunt servanda means the obligation is followed, right?
Yes, Your
The
Honor.
powers are followed, right?
The obligations...
And the treaty accepts and gives the privileges to a state party to withdraw, correct?
Yes, Your
And
Honor.
the Philippines withdrew, whatever its reasons, it says in the treaty that that withdrawal will be respected as soon as it is deposited, but will take effect 1 year after, correct?
That's what is provided for in the Rome Statute, Your Honor. We agree.
So there is still a violation of pacta sunt servanda.
In the sense, Your Honor, that there is an expectation that if we become party to
Wait,
a...
maybe your expectation, but let's be clear, as lawyers, Article 127 allows withdrawal, correct?
Yes, Your Honor.
Yes. There is no reason that must be stated for the withdrawal, correct?
We agree, Your Honor.
That is a treaty power, a treaty immunity, a treaty privilege, a treaty obligation, correct?
Yes, Your Honor.
So, therefore, when the Philippines withdrew, it was in violation of pacta sunt servanda?
Well, if you only look at Article 127, Your Honor, then no.
What else will we look at?
Well, as we argue, Your Honor, our position is that upon entering the treaty, there is an expectation that we actually adhere to its principles with a certain degree.
Well, the
of-
treaty has a principle called Article 127, which says a state party may withdraw.
Yes, Your Honor.
Yes, and we disrespected that by withdrawing. I do not get the argument on pacta sunt servanda, because here you're not dealing with international customary law where the articulation is evolving. You're not dealing with we are dealing with treaty law where the articulation is very clear. 2 paragraphs in Article 127, and no matter how much I read it, forwards and backwards, I do not see the requirement that we should have a reason for withdrawal when we deposit that instrument. Correct?
We respect your position, Your Honor.
Yes, and therefore, pacta sunt servanda is not really involved in this case.
I suppose if you frame it that way, Your Honor, then yes.
Okay, so thank you. I have no further questions.
Counsel,
Yes, Your Honor.
how is a law repealed, amended, or withdrawn?
By a subsequent enactment of Congress, Your Honor.
Is there a provision in the Constitution stating that?
No, Your Honor.
So what's your basis?
The general understanding of what the legislative power entails, Your Honor, as well as various decisions of the Supreme Court specifying that laws are repealed by subsequent enactments, explicitly providing for such repeal, or which are incompatible with earlier legislation, Your Honor.
A law has to be implemented by the executive, correct?
Yes, Your Honor.
Okay. Now, if there are 2 laws that are inconsistent and they cannot be reconciled, what happens?
Then the law which is later in time, Your Honor, will prevail, and the earlier law will be deemed repealed.
So that is the way to repeal an earlier law. Pass another law abrogating the prior law, correct?
Yes, Your Honor.
So, is there a provision in the Constitution on that?
Not to my mind specifically, Your Honor.
There's none, but that has been the statutory construction by the court
Yes,
ever
Your Honor.
since.
Yes, Your Honor.
So, there is no provision in the Constitution saying how a law can be withdrawn, repealed, or amended, but we all know that if there's another law subsequently passed that's irreconcilably in conflict with the earlier law, then the earlier law is repealed, correct?
Yes, Your Honor.
Now, what is the status of a treaty?
It's considered to be equivalent to a statute, Your Honor, in domestic law.
It's equivalent to a municipal law.
Yes, Your Honor.
Now, if there is a, for example, you have the National Internal Revenue Tax Code.
Yes, Your
It
Honor.
imposes taxes on importation of vehicles, importation of equipment. Subsequently, there's a treaty signed, a tax treaty, saying that importation of certain equipment shall not be subject to tax.
Yes, Your Honor.
And this treaty is later than the National Internal Revenue Code. So there's an irreconcilable conflict. Which will prevail?
The treaty provisions, Your Honor, considering that they were adopted and came into force later in time, Your Honor.
Now, the Multilateral Convention on Special Missions, to which we are a party, it's a convention. Most states have signed this. State that the diplomatic missions here of other countries are exempt from taxes, duties, etc., with respect to their imported equipment, cars, etc. So, this convention is contrary to the National Internal Revenue Code, contrary to the Tariff and Customs Code. Which will prevail?
The treaty, Your Honor.
Convention. It's a multilateral treaty, correct?
Yes, sir. Yes, Your Honor.
But there is no law, there is nothing in the Constitution which says that, correct?
Not explicitly, Your Honor.
But we know because there are two contrary laws, and we have to interpret it by statutory construction. If there is an irreconcilable conflict, the later will prevail, correct?
Yes, Your Honor.
Do you know of multilateral treaties that amended Philippine law? How about the WTO?
Yes, Your Honor.
It even amended, according to that decision, part of our sovereignty, correct?
Yes, Your Honor.
Well, I'm not, I think, personally, I think that went overboard, but definitely it can amend a treaty, it can amend a prior law, correct?
Yes, Your Honor.
How about the different tax treaties?
Yes, the different tax treaties would have the effect, Your Honor, of amending.
In fact, we have a decision which says the National Internal Revenue Code are always subject to subsequent treaties.
Yes, Your Honor.
Tax treaties. Now, in the case of a treaty, you said it has the status of a law. You say that because the treaty can amend a law. So only a law can amend another law, correct?
Yes, Your Honor.
Only a law can repeal a law, correct?
Yes, Your
So
Honor.
if the treaty can amend or repeal a prior law, it must be a law itself, correct?
Yes, Your Honor. It has
So it's a special kind of law under the Constitution, correct?
It is, Your Honor.
Because the treaty is negotiated by the President, but it does not have any effect until concurred by the Senate, correct?
Yes, Your Honor.
Now, the concurrence of the Senate to give it effect is a matter of constitutional law, correct? It
Yes, Your
cannot be
Honor.
given effect any other way.
Yes, Your Honor.
Now, how about the withdrawal of that? Withdrawal from the treaty by the country. Is that a matter of constitutional law also?
It is our position that it is, Your Honor.
So it doesn't matter what the Senate as a policy does. It may or may not incorporate in the concurrence that any withdrawal shall require the consent of 2/3 of the Senate. It doesn't matter. That will not add to the requirement that the withdrawal must have the conformity of the Senate, correct?
Yes, we fully agree, Your
If,
Honor.
as a matter of constitutional law, the withdrawal requires consent of the Senate, then any additional phrase added by the Senate in the concurrence will not change that, correct?
Yes, Your Honor.
So, even if the treaties now concurred by the Senate provide that any withdrawal shall require two-thirds consent of the Senate. It doesn't really mean that earlier treaties will not require concurrence, correct?
Yes, Your Honor.
Because it's a matter of constitutional law. The Senate cannot amend the Constitution, correct?
It cannot, Your Honor.
So if the Constitution requires it, it's regardless of what is the policy of the Senate when it gives the concurrence, correct?
Yes, Your Honor.
Now, you said that the treaty has the status of a municipal law,
Yes, Your Honor.
and it can only be withdrawn with the concurrence of the Senate.
Yes, Your Honor.
What if Congress, both chambers, House and the Senate, will pass a law that is irreconcilably in conflict with the treaty? So this is a later law. Which will prevail?
The later law, Your Honor.
So, in effect, it's not only the Senate and the President who can withdraw or repeal a treaty. It can also be the entire Congress, correct?
Yes, Your Honor, as a matter of domestic law.
And Congress can pass a law by what majority?
By a simple majority, Your Honor, there being a quorum.
What is the quorum?
It's 50% plus 1, Your
So
Honor.
what is the majority of 50% plus 1? Assuming there are 300 members of the House, there are, I think, 297, but for
Yes, Your Honor.
purposes of our discussion, you were a member of the House once. So what if the membership is 300, so a majority is 151?
Yes, Your Honor.
And
Then a simple majority would be 76 members of the House, Your
so
Honor.
76 members of the House, and how many in the Senate? What is the quorum in the Senate?
Currently, Your Honor, quorum in the Senate.
13.
13, Your Honor, yes. So it's 7 members of the Senate, Your Honor.
7
would be
members
sufficient.
of the Senate. So 7 members of the Senate and about 70 plus in the House can repeal a treaty.
Yes, Your
They
Honor.
pass a law.
Yes, Your Honor, provided that the President
Does not
likewise...
veto.
Yes,
Does
Your
not veto it.
Yes, Your Honor.
Assuming the President vetoes it,
Then it will go back to both houses, Your Honor, and they can override the veto with a 2/3 vote of all
of
members.
its chamber,
Yes, Your Honor.
which shows that legislation is a legislative function, because the legislators can override a veto. They can pass a law by themselves without the concurrence of the President, correct?
Yes, Your
Over
Honor.
the objection. So legislation is lodged in Congress, correct? It's
Yes,
a
Your Honor.
legislative power.
Yes, Your Honor.
Now, when a president assumes office, what does he promise to the nation under oath?
He promises to faithfully execute the laws, Your Honor.
His oath of office says he will faithfully and conscientiously execute the law, correct?
Yes, Your Honor.
And in another provision, it says he shall ensure that the laws be faithfully executed, correct?
Yes, Your Honor.
If the constitutional duty of the president is to faithfully execute the law, does it include the power to amend the law,
Well, no, Your Honor.
to withdraw the effectivity of a law?
No, Your Honor.
Doesn't. If he wants to amend the law, he goes back to Congress, correct?
Yes, Your Honor.
If he wants to withdraw from a treaty, he goes back to the Senate, correct?
Yes, Your Honor.
Okay, thank you, Counsel.
You're familiar with Article 7 of the Civil Code?
Yes, Your Honor.
You can state that. Can you read Article 7 of the Civil Code?
Yes, Your Honor. Laws are repealed only by subsequent ones, and their violation or non-observance shall not be excused by disuse or custom or practice to the contrary. When the courts declared a law to be inconsistent with the Constitution, the former shall be void and the latter shall govern.
There's no mention of treaty.
No, Your Honor.
So your statement a while ago that there is nothing in our legal system which actually says that a law can be repealed only by a subsequent law is not actually true.
There's nothing in the Constitution,
Yes,
Your
but
Honor.
there is now a legislative determination that the only way to change a law is by another law, correct?
Yes, Your Honor.
Is there a legislative determination that there is a power that the withdrawal to a treaty must always be concurred in only by the Senate?
Not that I'm aware of, Your Honor.
So, in other words, for one, there is now a determination by the political entity, constitutional body called Congress. The other one, there is none. Okay, let me clarify a few other things.
Yes, Your
Can
Honor.
law repeal a treaty?
Yes,
Can
Your
laws
Honor.
repeal a treaty?
Yes, Your Honor.
Therefore, there can be a law which actually says that the president does not have the power to enter into a treaty, correct?
I'm sorry, Your Honor.
There can be a law which says, which contains provisions which actually disallow the president to be able to participate in the in a particular kind of treaty where the provisions are inconsistent, correct?
Yes, Your
Maybe to
Honor.
put it another way, can this court declare a treaty to be invalid?
Yes, Your Honor.
Yes, we have the jurisdiction, correct?
Yes, Your Honor.
Article 8, Section 5,
Yes, Your Honor.
correct. And the treaty can be invalid because it does not concur with or is not in harmony with the Constitution, correct?
Yes, Your Honor.
And it is also not in harmony with the law, correct?
Yes, Your Honor.
Yes, correct? Do we have that power?
Just a moment, Your Honor.
We can declare a treaty to be invalid, correct?
Yes, Your Honor.
Yes. So we can declare it to be invalid because it is not consistent with the Constitution, right?
Yes, Your Honor.
Yes. We can also declare a treaty to be invalid because it is contrary to an existing law, correct? Are you reading the Bible or is that?
No, Your Honor. My understanding, Your Honor, of Section 5, Article 8 is that the basis must be unconstitutionality, Your Honor.
You mean to say that Congress does not have the power to actually say that the president's power to do foreign relations is dependent on certain norms within his own jurisdiction?
Congress has the power to say that, yes,
Yes.
Your Honor.
So, Congress has that power because Article 6, Section 1 says that legislative power is vested in Congress, correct?
Yes, Your Honor.
And the president executes the law, correct?
Yes, Your Honor.
And therefore, when the president enters into a treaty contrary to an existing law, it cannot be, right?
My understanding, Your Honor, is that Article 7, Section 21, the treaty clause, explicitly grants a shared power to both Congress
But that's
and
not answering my question. Can the president enter into a treaty which is contrary to an existing law?
Yes, Your Honor, so long as the Senate
Really?
concurs.
I thought the president took an oath under Article 7 to strictly enforce all the laws, right?
Yes, Your Honor.
Yes, and the president therefore acknowledges that insofar as he or she will be concerned, that it is important that they respect what is the existing law now prevailing, correct?
Yes, Your Honor.
And to that certain extent, Congress does participate in foreign relations.
Yes, Your Honor.
By, for example, if it passes a law which says tarification of rice, no more quantitative restrictions, only tarification. Can the president enter into a treaty where it commits quantification, quotas?
The entry of the President into the treaty, Your Honor, would require the
The
concurrence of the
president
Senate.
enters into a treaty and Senate concurs with it, can this court say that it entered into an invalid treaty?
My understanding, Your Honor,
Or are
is
you
that-
saying that the President and the Senate alone can overturn the action of a House of Representatives where there are legislative districts and party lists, and the Senate and the President? That it can overturn it by simply entering into this negotiated treaty with only 2/3 of the Senate concurring?
Yes, Your Honor.
So, in other words, you're saying that the President is not bound by a previous law when it enters into a treaty.
The President is bound, Your Honor,
So
but
when the President enters into a treaty contrary to an existing law, can that treaty be declared invalid?
no, Your Honor, because if it's valid under
How
Article
can
7...
how can it not be invalid when it is contrary to an existing law?
Because if the Senate actually exercises its power to concur, Your Honor, then it's not simply
So
the
it becomes
President...
law.
Yes, Your Honor.
You mean to say that a prior law which told the President, when you enter into a treaty, only tarification of rice, no other exception. And the President enters into quantitative restrictions, still enters into a quota. That President has entered into, that's a correct constitutional theory. The President, therefore, has repealed a law by himself. That's why I'm asking you, does the President have the power of implied legislation?
Well, it's not the President.
Can a treaty amend an existing law?
Yes, Your Honor.
Really?
That's my
So
understanding
when
of
the
the treaty
President
clause, Your Honor.
who takes the oath under the Constitution, I shall follow the Constitution and all laws.
Yes, Your Honor.
It doesn't really mean that. The President can do anything it wants so long as it has the international cover.
Definitely not, Your Honor.
So it can enter into a treaty with Timbuktu, Zarathoa, whatever state, which actually amends the laws in the Republic.
Yes, Your Honor, because
so therefore, the
entry...
President can become a dictator.
Of course not, Your Honor. But entry, we have to remember, Your Honor,
You
that
are saying that the democratic deliberative actions of the House of Representatives and Congress and the President that passes a Republic Act, that Republic Act can be modified by the President negotiating a treaty and only with the concurrence of 2/3 of the majority of the Senate. Never mind the House of Representatives where you have a party list like Akbayan, where you have legislative districts, where people are represented by their legislative districts. The President can overturn that law.
not the President by himself, Your Honor, but
And
the
2/3 of the
President,
Senate.
the President and the Senate exercising the power jointly
that
under...
a treaty can amend a law.
Yes, Your Honor.
And you're saying, therefore, that the President can go ahead and do something illegal in the international sphere, so long as the Senate concurs with it, we are going to treat it as valid.
It will not be illegal, Your Honor, if the Senate concurs, considering that we will now be
No,
in
under my
compliance...
theoretical example.
I'm sorry, Your Honor.
Under my theoretical example.
Yes, Your Honor.
Yes, where I said tarification of rice, only tarification.
Yes,
the
Your Honor.
President enters into a quota.
Yes, Your Honor.
So the President's action is valid.
Provided that it is actually in accordance with the rest of the requirements of Article 7, Section 21, Your Honor.
Okay, so it says that only if there is a clear provision, then you can say that it will be inconsistent, correct?
Yes, Your Honor.
Yes. Now, under Republic Act 9851, was there a requirement that the President stays with the International Criminal Court?
No, Your Honor.
None, right? Had Congress wanted him to stay, they could have provided in Republic Act 9851, correct?
Well, when Republic Act 9851 was passed, Your Honor, we were not yet a party to the Rome Statute.
Yes, but in any case, had Congress wanted the President to stay with the International Criminal Court, it could have so provided, clearly, correct?
I suppose it could have, Your
Yes,
Honor.
in fact, some of the petitioners were actually actively involved. The lead petitioner here, the Philippine Coalition for the International Criminal Courts, I hope I got your name correctly, represented by the able lawyers here, including the presidential spokesperson today, if I'm not mistaken, our good friend, Professor Harry Roque, led with Congress and senators, Senator Miriam Defensor Santiago, among others, led in crafting Republic Act 9851, correct?
Yes, Your Honor.
Yet there is nothing there which actually says that we shall forever be bound with the International Criminal Court.
Because as I said, Your Honor, at that time, we were not bound at all with the International Criminal Court.
Is the United States a part of the ICC?
It is not, Your Honor.
Russia?
No, Your Honor.
China?
No, Your Honor.
Are they violating Pacta Sunt Servanda?
Not with respect to the ICC, Your Honor,
Not with
considering that
respect to
they
the
are not...
ICC. So it is not totally being a pariah not to be a member of the International Criminal Court, correct?
Well, if you would
The
consider...
Nuremberg trial, was it created by the, is it under the ICC? The
No, Your
Nuremberg
Honor.
Court. What created the Nuremberg Court?
Well, it was the Allied powers, Your
Yes.
Honor, that
The
it
Allied
constituted.
powers entered into an agreement amongst themselves in order to convict German nationals coming from the Axis state, correct?
Yes, Your Honor.
Yes. What about the Tokyo Court? ICC?
No, Your Honor.
No. What about International Court of the International Criminal Tribunal of Yugoslavia?
No, Your Honor.
Security Council, correct?
Yes, Your Honor.
International Criminal Court of Rwanda.
No, Your Honor.
Security Council, right?
Yes, Your Honor.
The Special Courts of Sierra Leone.
No, Your Honor.
Again, by treaty, correct?
Yes, Your Honor.
What about South African Truth and Reconciliation?
No, Your Honor. That was a domestic enactment, Your
Domestic enactment, which they saw as necessary in order to transition from their post-revolutionary status and in order to address the difficult circumstances under the situation of apartheid, correct?
Yes, Your Honor.
So there are many other ways by which immunity can be prevented, correct?
Yes, Your Honor. But in all these
Not only
examples...
the International Criminal Court, correct?
I'm sorry? Yes, Your
Not
Honor.
only the International Criminal Court.
Yes, but the difference...
So now we have the situation where there was already a deposit, correct?
Yes, Your Honor.
March 17, right?
Yes, Your Honor.
A note verbal by the DFA,
Yes, Your Honor.
accepted already by the Secretary General.
Yes, Your Honor.
Yes, and you want us to issue a writ of mandamus
Yes, Your Honor.
to tell the President to withdraw.
Yes, Your Honor.
What if he doesn't withdraw?
Then he would be in violation, Your Honor, of the Constitution.
Can we actually declare the President in contempt? Or are we in a situation where this is a Republican government where the Supreme Court does not preside over everything?
Well, that's true, Your Honor, but going by that argument, then the court would be prohibited from issuing any
No, we
order
can.
to the executive, Your Honor.
No, we can issue a writ of prohibition or a writ of certiorari before it was deposited. But after it was deposited, it would be a different situation altogether. But in any case, Counsel, please discuss in your memoranda situations where this court actually issued the writ of mandamus to the President of the Republic.
We will do so, Your
Yes,
Honor.
thank you.
Delesa?
Counsel,
Yes, Your Honor.
the fact that, as confirmed by Senator Pangilinan a while ago, that on December 5, the Senate, in ratifying the agreement on the Asian Infrastructure Investment Act, put in the requirement that withdrawal can only be done with the concurrence of 2/3 of the Senate. And as Senator Pangilinan confirmed a while ago, since then, up to this year, there are about already 17 such concurrences by the Senate. That has not been raised in your petition nor in the presentation that you gave us earlier. Is there any particular reason why not?
Because, Your Honor, to our mind, it is actually irrelevant what the Senate expresses in terms of its sense on how Article 7, Section 21 should be interpreted. Ultimately, this is a constitutional matter that the court should be the one to decide it with finality.
Okay. So now, you're familiar with the Goldwater case in the United States,
Yes, Your Honor.
where 4 justices on the issue of the unilateral withdrawal by President Carter, I think,
Yes, Your Honor.
from the Taiwan-U.S. Mutual Defense Pact, was questioned in the U.S. Supreme Court.
Yes, Your Honor.
4 justices declared it a political question. The 5th, Justice Powell, said the issue was not ripe.
For adjudication, yes, Your Honor.
Now, I would have thought that if you read the case carefully, much of it turned on the fact that in the United States, there has been a long history of the American president unilaterally withdrawing from treaties. Isn't that right?
Yes, Your Honor.
In fact, I think it's more than 150 years since the time of their Constitution.
Yes, Your Honor.
And in fact, the State Department of the United States has since taken the position that the President of the United States has the unilateral power to withdraw from treaties.
My understanding, Your Honor, is that that's only for specific circumstances surrounding the withdrawal, Your Honor.
That is why when the U.S.-Taiwan treaty was withdrawn by President Carter, you had the Goldwater case.
Yes, Your Honor.
What I'm driving at is, it seems to me, in the United States, where the provision is very similar to ours, it speaks of a Senate concurrence to a treaty negotiated by the President. But both there and here, it doesn't say how does one get out of a treaty, not textually.
Yes, Your Honor.
And therefore, in that case, and at least in the United States, there is so much practice on the part of the U.S. President to unilaterally withdraw from treaties.
Yes, that has been the practice, Your
Which
Honor.
I now ask you, in the Philippines, there is no such practice, right?
No, Your Honor.
That is why this is the first time that a Philippine president has sought to withdraw from a treaty.
Yes, Your Honor.
And again, I will not replay the issue because I think both parties agree that textually there is no constitutional provision providing for how does the Philippines get out from a treaty.
Yes, Your Honor.
So it seems to me now that you are asking this court to declare that the way to get out of a treaty is to have Senate concurrence.
Yes, Your Honor.
But since it is not textually so provided, I go now to the fact that the Senate, after this controversy cropped up, has now 17 treaties where it is saying the only way to unmake a treaty is to have the concurrence of the Senate.
Well, actually, Your Honor, considering that Resolution 33 concerning the concurrence to the Asian Infrastructure Investment Bank Treaty was enacted in December of 2016. That occurred prior to the withdrawal from the ICC, Your Honor.
That's right. And then you have, of course, again, the climate Paris Agreement.
Yes, Your Honor.
So to me, there is some argument there that, unlike in the United States, where the practice is in favor of unilateral power by the president more than 150 years, here, however short, it's only 2016, the Senate has a different practice. And now you have two different experiences. In the U.S., given that practice, they brought the case to the U.S. Supreme Court, and you have the decision in Goldwater, and we have this case now. But in the absence of textual definition of who can get out of a treaty, your structural argument could have as an additional prop the fact that the Senate since 2016 has been putting in that condition.
Yes, Your Honor.
No further questions.
Thank you, Your Honor.
Good afternoon.
Good afternoon, Your Honor.
It is clear that the Senate, as a body, has not officially asserted its supposed authority to approve the withdrawal from the Rome Statute.
Respectfully, Your Honor, it is our position that it has through the inclusion of provisions in 17
The Senate
treaty
has not
concurrences.
adopted and passed a resolution declaring that its concurrence is necessary to validate the withdrawal from the Rome Statute.
There is no specific resolution to that effect, Your Honor, but the fact that in 17 concurrences, Your Honor, it has specified...
Should this court act favorably on the petition?
We believe so, Your Honor.
And compel the Senate to give its concurrence to the withdrawal, will that not be interpreted as an intrusion into the powers of the Senate, considering that they have not formally adopted a resolution requiring concurrence? for the withdrawal?
The power, Your Honor, of the Senate to concur in withdrawal of treaties is provided for in the Constitution. And regardless of whether or not...
Concurrence to withdrawal is in the Constitution?
That is our position, Your Honor. It's necessarily implied in Article 7.
What I'm saying is, the Senate has not officially asserted its authority, has not officially adopted. That's what is evidently clear to the court. It passed the resolution expressing its sense, correct? But the Senate has not actually adopted a resolution demanding that its concurrence to the withdrawal be secured.
Your Honor, in the 17 instances where
So it's answerable by yes or no. Has the Senate officially asserted its authority to demand concurrence to the withdrawal from the Rome Statute?
Not for the Rome Statute.
All right. Now, do you think there is already a constitutional impasse, considering that there is absent an official stand on the part of the Senate, and therefore there may not be a justiciable controversy that is ripe for adjudication by this court?
We believe, Your Honor, that the issue is already ripe for adjudication, considering that the submission of the note verbal to the United Nations has already had an effect. The one-year period is currently proceeding, Your Honor, and unless the Honorable Court decides in favor of the petitioners, that will take effect, Your Honor, in violation of the prerogative of the Senate under Article 7, Section 21.
When the instrument of notification of withdrawal was submitted to the ICC, it was accepted?
Yes, Your Honor.
It was not rejected?
Yes, Your Honor.
Did the ICC say that the withdrawal was incomplete?
No, Your Honor.
Did the ICC say that the withdrawal was invalid?
No, Your Honor.
All right. Now, it has been asserted that a treaty, once ratified and approved, becomes part of the municipal or domestic law.
Yes, that's the doctrine of transformation, Your Honor.
Are you saying that treaties are on the same level as statutes?
Yes, Your Honor.
Isn't it that statutes can become laws even without presidential approval?
Yes, Your Honor, if they are...
And treaties, on the other hand, cannot become part of the domestic law without presidential approval and ratification.
That is true, Your Honor.
All right. So can it therefore be said that though forming part of the municipal law, treaties cannot be treated in the same manner as statutes?
Well, insofar as effect is concerned, Your Honor, they would be of the same level as statutes insofar as municipal law is concerned.
Can it be accordingly be also argued that the process of repealing statutes do not necessarily apply to treaties?
Under domestic law, Your Honor, considering the status of a treaty as a statute, then they would be subject to the same rules that govern the repeal of legislation duly enacted by Congress, Your Honor.
Are you familiar with the Vienna Convention on the Law of Treaties, VCLT?
Yes,
And
Your Honor.
who are authorized to bind the state to international commitments? If you're not familiar with it, it speaks of heads of states, heads of government, ministers for foreign affairs, officials with full powers as authorized to bind the state to international commitments and to withdraw from those same commitments. Article 7 makes an enumeration under the Vienna Convention on the Law of Treaties. Now, the question is, under international law,
Yes, Your Honor.
under the VCLT, Vienna Convention on Law of Treaties, can the state invoke its internal law, its constitution, to invalidate its consent to be bound by a treaty? For example, President Duterte signed the treaty without Senate concurrence. Can we now invoke to the other party of the treaty that we are not bound by it because there was no Senate concurrence?
No, Your Honor, not under international
Because
law.
under Article 46, a state may not invoke the fact that its consent to be bound by a treaty has been expressed in violation of a provision of its internal law regarding competence to conclude treaties.
That is correct, Your Honor, insofar as international law is concerned. But if the President would do that, Your Honor, he would still be accountable under our own Constitution and municipal law.
All right, I am done. I think Soljan Kalida may no longer have to go and argue his position because of the many questions we asked. Thank you, Chief.
Good afternoon.
Good afternoon, Your Honor.
I'm not an expert in international law, let me tell you right off. So my questions are really meant for me to understand.
Yes, Your Honor.
All right. Let me go straight to the two treaties that I'm focusing on, the ICJ statute and the Rome statute creating the ICC.
Yes, Your Honor.
Can you tell the court what are the rights and obligations created by the ICJ statute?
Under the ICJ statute, Your Honor, the Philippines as a state party agrees to be bound by the jurisdiction of the International Court of Justice. And it can be brought before the ICJ, Your Honor, if there is a dispute with another state party.
So who can sue in the ICJ?
State parties, Your Honor.
Who can be sued in the ICJ?
State parties as well, Your Honor.
Okay. What about the Rome statute? Who can access the ICC mechanism?
Well, both state parties and individuals, Your Honor, can access the ICC mechanism.
So the ICC has jurisdiction over natural persons?
Yes, Your Honor.
Okay, I'm referring to Article 1 of the Rome Statute. It says, the court, an international criminal court is hereby established. It shall be a permanent institution and shall have the power to exercise its jurisdiction over persons for the most serious crimes of international concern.
Yes, Your Honor.
So under the Rome Statute, an individual, which is a group of Filipinos, for example, can actually lodge a complaint or a cause of action before the ICC against another person.
Yes, Your Honor.
So he does not need his state to act for him.
No, Your Honor.
So if the Philippines withdraws from that Rome Statute, do I understand it correctly that these Filipinos who have a cause of action would no longer have any direct recourse or remedy against that natural person in the Philippines? Is that correct?
Well, their remedies would be confined to the domestic remedies available under Philippine law, Your Honor. But insofar as the ICC process is concerned, for acts committed after the effectivity of the withdrawal of the Philippines, they would no longer have recourse to the ICC, Your Honor.
And if there is no more recourse in the Philippines, what is the role of the ICC in that situation?
Well, unless there is a subsequent referral, Your Honor, by the Philippine state invoking ICC jurisdiction, then there would be no longer any recourse for these individuals, Your Honor.
Now, I'm referring to the complementary principle. Should the Philippine courts be unwilling or unable, then there will be a recourse of that group of individuals before the ICC against another individual in the Philippines?
No longer, Your Honor, after the effectivity of the withdrawal becomes complete.
So it disappears?
Yes, Your Honor.
And it disappears 1 year after the deposit of the instrument of withdrawal. Is that correct?
Yes, Your Honor.
So do you agree with me that to that extent, there is a direct impairment of one's rights created by the Rome Statute or by the Philippines' accession to the Rome Statute suffered by the individual Filipinos or the individual Filipinos?
Yes, Your Honor.
Let me go to a historical perspective. I think Justice Marvick, who is the expert, not I, has gone into, and he mentioned the Nuremberg trials. He also mentioned the Tokyo trials, the International Criminal Tribunal for the former Yugoslavia. That's for the ethnic cleansing abuses, correct?
Yes, Your Honor.
He also mentioned the Criminal Tribunal for Rwanda. All of these proceedings were all ad hoc, correct?
Yes, Your Honor.
And they all preceded the establishment of the ICC as a convention amongst countries, correct?
Yes, Your Honor.
Therefore, can you tell me how, because we're talking about whether or not there are other remedies outside of the ICC, do these ad hoc situations afford a real honest-to-goodness remedy to an individual Filipino?
No, Your Honor, because considering that these are ad hoc remedies, unless there is actual specific action taken by a body such as the Security Council, there is no guarantee that a court will actually be set up to receive these kinds of individual complaints, Your Honor.
Let me rephrase my question. How difficult would it be to constitute these ad hoc committees to investigate and penalize these individuals who have committed crimes?
I would think it would be very difficult, Your Honor, considering that in the history of the international community, the ICTR and the ICTY are only two of the most obvious examples that it has actually happened, Your Honor. And there are many other situations in multiple states where individuals were not given any recourse, considering that there was no action on the part of a body like the Security Council.
So it would be very difficult.
It would be very difficult, Your Honor, yes.
And the way I'm reading it is that the Rome Statute is precisely the answer to that, because under the Rome Statute, a permanent court is created by which every Tom, Dick, and Harry, strictly speaking, can actually access that mechanism, and they don't have to go to their individual states to force the composition of an ad hoc committee. ICC is there, correct?
Yes, that is one of the principal reasons for the creation of the ICC, Your Honor.
So, I guess my ultimate question is this, Counsel. How important to the ordinary Filipino is the Rome Statute? Why is it important?
It is important, Your Honor, because it provides a safety mechanism in effect. In a situation where domestic courts are unable or unwilling to actually provide justice to victims of the serious crimes enumerated in the ICC, then a Filipino would have an additional recourse, this time to a standing international court, which is the ICC, Your Honor.
So we're talking really about two levels of redress. You have an internal redress mechanism, which is your national law.
Yes, Your Honor.
And surrounding that is the international mechanism called the ICC. Do I capture that correctly?
I believe so, Your Honor, yes.
Can I ask Attorney Bagares, because Justice Marvick has been mentioning how active you have been in the accession of the Philippines to, and I understand you've spent years pushing for this accession. Is that correct?
Well, in Pimentel, Your Honor, I was a petitioner, Your Honor.
And I'd like to hear from you, because you were one of the main proponents, or for lack of a better word, lobbyists for this.
Yes, Your
Why
Honor.
is this important? Why should it be important to me? Why should it be important to every Tom, Dick, and Harry here?
It's not apparent, Your Honor, to many people, but if our courts are unable, or there's inaction in the part of our courts, Your Honor, we don't have any recourse internationally, Your Honor, because we are no longer a party to the ICC.
Okay, so we're not really talking about the current situation. We're really talking about a situation maybe in the future whereby a despot, an out-and-out dictator, will actually close down the Philippine courts, prevent any access of Filipino, and that ordinary Filipino can now go to the ICC and seek some redress against the abuses of this dictator, correct?
Yes, Your Honor.
And all of that disappears.
After March 17, 2019, Your Honor.
It will disappear.
It will disappear, Your Honor.
And to that extent, would you agree with me that that is a direct injury that you yourself will suffer?
Very much, Your Honor.
Okay, thank you.
I am excused, Your Honor. Thank you.
Attorney Gutierrez,
Yes,
just to
Your
be
Honor.
accurate, the ICJ does not provide for compulsory jurisdiction, correct?
No, Your Honor.
requires the consent of both parties in order for it to exercise full jurisdiction, correct?
Yes, Your Honor.
So it is unlike, let us say, the tribunals for the law of the sea, where it has to make a decision on its jurisdiction, but insofar as the ICJ is concerned, it does not have compulsory jurisdiction.
That's correct, Your Honor.
Unlike the appellate body of the WTO, it does have compulsory jurisdiction, correct?
Yes, Your Honor.
The ICC also has compulsory jurisdiction for so long as you are a state party, correct?
Yes, Your Honor.
Yes, but it can also have jurisdiction when there is a referral from the Security Council, correct?
Yes, Your Honor.
Yes, like this case of the Rohingya in Myanmar, correct?
Yes, Your Honor.
Yeah, where they are still discussing whether they should refer it to the International Criminal Court, correct?
Yes, Your Honor.
Yes, and to be accurate, there is no complaint that is filed by an individual citizen, right?
No, Your Honor.
It is called, rather not a complaint, it is called
a communication. Your Honor.
communication. It's called a communication because there are no charges. They are only going to explain a situation, and the prosecutor will determine whether, in fact, number one, it can have jurisdiction. Number two, it passes Article 17. And number three, it passes to a pretrial chamber, correct?
Yes, Your Honor.
Yes, and therefore, it is not that easy, correct?
No, you're correct, Your Honor.
Yes. In other words, there is, in terms of international law, other remedies, correct? For example, a communication sent to the UN Committee on Human Rights, correct?
Yes, Your Honor, but the
Or
result of that would be
review,
different, Your Honor.
The annual review being done, or the biannual review being done, as a measure of our compliance with the International Convention on Civil and Political Rights or the International Convention on Economic and Social Rights, correct?
Yes, Your Honor, but
For the international community to be seized of the attention of the situation that happens in the Philippines, correct?
yes, Your Honor,
Okay, now,
but
Article 17 requires for a communication to ripen into a complaint, besides jurisdiction over the person, over the time, over the subject matter, and over the place, it also requires, number one, complementarity, correct?
yes, Your Honor.
Unwilling and unable, correct?
Yes, Your Honor.
So it is up to the international community, the ICC, the prosecutor first, the pretrial chamber second, and the court itself later
Yes, Your
on,
Honor.
to determine whether or not there is unwillingness and inability, correct?
Yes, Your Honor.
Okay, inability is that there are no courts almost. Correct?
Yes, Your Honor.
This is a situation where all courts are closed down or substantially unable to perform their duties, correct? Because of a conflagration, etc.
Or there is otherwise a legal bar, Your Honor.
In such a
to-
situation, it will be so obvious to the international community that it can be raised by anybody in any of the international bodies, correct? Inability.
Yes, Your
Yes.
Honor.
Unwillingness is also a similar situation, correct? That the unwillingness of the courts are so obvious such that courts do not acquit those offenders of drugs. Courts do not issue writs of amparo. Courts do not issue writs of habeas corpus. There is no Republic Act 9851. That's unwillingness, correct?
Those would be examples of
But the
unwillingness.
reverse is
Yes, Your
happening
Honor.
in the country. For example, there are writs of amparo that are issued by this court. There are acquittals that are happening. There are complaints that are now pending in terms of this court and many other courts, correct?
Yes, Your Honor.
So for unwillingness to happen, it must be again so egregious, so ubiquitous, so obvious that it can be taken on by the international community, correct?
Yes, Your Honor.
Yes. But that is not the only requirement. As a matter of fact, there is the second paragraph, that there is such gravity of the situation, correct?
Yes, Your Honor.
Yes. And in fact, our law does not require gravity. Republic Act 9851.
No, it doesn't.
That doesn't require gravity. In fact, our law does not require complementarity. It requires the reverse, correct?
Yes, Your Honor.
There is reverse complementarity. Can you explain that?
It means, Your Honor, that the assumption is that 9851 will apply.
No. Reverse complementarity. It says that an authority may cease investigation if there is a referral to an international court or a foreign court, correct?
Yes, Your Honor.
Which is strange, right? Which is even better than ICC because it now says the reverse of the treaty, correct?
Yes, Your Honor.
Yes,
I
it's
suppose.
there in, if I'm not mistaken, Chapter 7, Section 9, if I'm not mistaken, of the actual Republic Act 9851. You can check me if I am wrong with the numbers, but it is there, correct?
Yes,
An
Your Honor.
investigating authority may, upon its option, be given the discretion to stop the investigation domestically when an international body has already taken cognizance of the situation, correct?
Yes, Your Honor. Although
Which is
that
strange because then the treaty actually amended our law, correct? The treaty, the International Criminal Convention, actually amended our law with respect to complementarity, right?
I don't think that there is a clear incompatibility, Your Honor, between the provisions of the
Isn't
ICC,
there?
the Rome Statute,
In
and
terms of reverse complementarity, our investigating authorities may cease jurisdiction, not continue with it if there is an international court or a foreign court that takes cognizance of it. But in any case, I just want to point that out. Okay.
Yes, Your Honor.
Next. That the international bodies will do better than the national bodies. That's a presumption, correct?
not necessarily, Your Honor.
That international bodies are always benign, that they will always do right, that there is no politics in international bodies. That may be an assumption, correct?
That's not our assumption, Your
Yes,
Honor.
it's a wrong assumption, correct?
Yes, Your Honor.
In fact, to strengthen the court system, to strengthen our domestic system, to strengthen the independence of our courts vis-a-vis the executive, for the courts to defer when it is a political matter rather than become a judicial dictator, rather than rely always on foreigners from a colonial mentality mode. I think that would be better. That can be a good assumption also, correct?
That perspective, Your Honor,
That
is
to
not
strengthen
incompatible
our
with...
institutions in order that citizens can get immediate recourse from our courts themselves, rather than to tell them that your courts are useless and therefore you will always have to rely on an international body so that there is no impunity. That can be a good assumption too, correct?
I would agree, Your Honor.
Yes, thank you.
Yes, Your Honor.
Now, considering that neither the Constitution nor the law contain any provision on treaty withdrawal, what law or constitutional provision is the court being tasked in this petition to interpret?
What we're asking, Your Honor, is for the court to issue an interpretation of Article 7, Section 21, Your Honor, of the Constitution.
Are there conflicting claims already that the court needs to resolve in this case?
Yes, Your Honor. It is the position of the executive that in the absence of an explicit rule on treaty withdrawal, then it should be assumed that the executive can withdraw unilaterally. The petitioners contend, however, Your Honor, that by necessary implication under Article 7, Section 21, considering that treaty creation or entry into a treaty requires both the action of the Senate and the President, then the same process must also apply to the act of treaty withdrawal.
Okay, but the Senate as a body has not asserted its prerogative, its shared authority over treaty withdrawal. Is that correct?
It has asserted its authority, Your Honor, in the 17 instances where it has concurred in treaties since December 2016, when it now includes as a provision in the resolution concurring in these various treaties that to withdraw a concurrence of the Senate will likewise be required.
All right, that will be all, Counsel.
Thank you, Madam Justice.
I have a few questions to ask, Attorney
Yes, Madam Chief
Gutierrez.
Justice.
Do you agree that there are two types of treaties or international agreement? A treaty or an international agreement which is self-executing and another one which is not self-executing?
My understanding, Your Honor, that in the Philippine jurisdiction, we do not make the distinction. All treaties by the doctrine of transformation are automatically considered as part of our domestic law.
You mean to say if there is a treaty and the treaty requires implementing legislation, then no implementing legislation is necessary for that treaty to take effect?
Well, unless the treaty itself requires, Your Honor, that implementing legislation be enacted in order to make it effective, then the presumption, Your Honor, is that the treaty itself can already be directly invoked within the domestic jurisdiction.
That means that treaty is not self-executing because it will require domestic legislation to put it in effect.
Yes, Your Honor, if that is so provided in the treaty
So
itself.
that is the principle of, that is the meaning of a treaty which is not self-executing.
Yes, Your Honor.
Because the treaty cannot amend an existing law unless a legislation is passed to amend existing law. If that is the provision of the treaty itself.
Yes, Your Honor, we agree, Your Honor.
If implementing legislation is necessary and such implementing legislation is not enacted by Congress, how will you implement a treaty entered into by the President even with the concurrence of Congress?
Then we submit, Your Honor, that in such a case, we cannot implement the treaty, considering that if its own terms require that implementing legislation be passed, then in the absence of such implementing legislation, it cannot be implemented.
What about the Rome Statute? Do you think all of the provisions of this statute can be put into effect without implementing legislation?
Yes, Your Honor.
What about the provision saying that the requested state can seize property? Can that be done without implementing legislation?
My understanding, Your Honor, is that there is ample basis under existing law for the Philippine government to seize state property. So there is no specific need to pass additional laws, Your Honor, because that power is already granted to the Philippine government under certain circumstances.
Do you think that can be done under the provisions of the Constitution?
Yes, Your Honor.
Requiring a court order for that to be done?
So long as it is done, Your Honor, in valid exercise of the police power, Your Honor, then I believe it would be upheld.
Okay, that will require an analysis of every provision of the Rome Statute, whether
Yes.
or not that can be implemented without implementing legislation coming from Congress.
Yes, Your Honor.
Now, let's go now to another point. A treaty, who has primacy in entering into a treaty? Is it the President or Congress or the Senate?
Well, it's a shared power, Your Honor, although the initial acts of negotiation and signing lie with the President, Your Honor.
Your position is that if there is a treaty entered into by the President and the Senate
Yes, Your Honor.
jointly,
Yes, Your Honor.
and the President would like to withdraw or to terminate that treaty,
Yes, Your Honor.
there's no way he can do that without Senate concurrence.
Yes,
That's your position.
that is our position, Your Honor.
So I'll give you a simple example. For instance, there is a treaty wherein the President agreed to give to a foreign state criminal jurisdiction over offenses committed within Philippine territory. And since this is a treaty, this was concurred in by the Senate. Now, if the President decided to terminate that treaty, can the Senate disagree with the termination of the treaty?
Yes, Your Honor. It's our position that to begin with, the decision of the President to withdraw cannot become or cannot be considered as valid under our own constitutional system until and unless the Senate concurs with a two-thirds vote, Your Honor.
A provision like that will need a treaty because that will amend the existing law on criminal jurisdiction.
Yes, Your Honor.
But so you're now saying if the President, based on the treaty, is allowed to terminate the treaty, the Senate can say, no, don't do that. Let's give that foreign state jurisdiction over criminal jurisdiction over persons committing crimes within Philippine territory. So you're saying the Senate can do that to withhold its concurrence to that kind of action done by the President?
Yes, Your Honor.
Now, for instance, I'll give you another example.
Yes, Your Honor.
The President agreed to give aid, military aid, to the military of a foreign state. And Congress agreed. And Congress said, okay, we support you. We will provide funds for that. And later on, the President decided not to anymore provide military aid to that foreign military personnel. You mean to say that the Senate can say, no, go ahead. You have to provide that military aid to that foreign state. We will not agree with you. Can the Senate do that?
Yes, Your Honor, because as soon as the process of entering into the treaty was accomplished by concurrence of the Senate with the initial action of the President, that treaty became, had acquired the force of law within Philippine jurisdiction. And so the President is duty-bound to implement it, and on his own, unilaterally, he does not have the power to withdraw without the same concurrence from the Senate, Your Honor.
But in that situation, there is a need for appropriation from Congress. And so you're saying the Senate should be forced to see to it that funds are appropriated for that, even if the President has decided not anymore to push through with the military aid to a foreign state?
Well, it would be exactly similar, Your Honor, to a situation where Congress has already provided for a continuing allocation for a particular purpose. Since that's a law, then I would assume that Congress would be duty-bound to continue funding the mandate provided for under a pre-existing law, Your Honor.
But if the treaty itself says that the country, one of the signatories can withdraw or terminate the treaty, you still would insist on saying that the Senate should force the President to comply with that treaty, even if there is such a provision saying that one of the signatories to the treaty can withdraw?
The provision on withdrawal, Your Honor, would govern the efficacy of the withdrawal insofar as international law is concerned. But what we're concerned with here, Your Honor, in this petition is the constitutional domestic rule on what makes that withdrawal valid within our own domestic law. So of course, a treaty would never include any provision that would require or prescribe what process each state has to follow within its own domestic jurisdiction. But our contention, Your Honor, is regardless of what the treaty may provide, we are still bound by the rules that our own Constitution itself provides insofar as the internal validity of a withdrawal is concerned.
We go back to the difference between a treaty that is self-executing and a treaty that is not self-executing.
Yes, sir.
So there is no legislation that will bind the President. That was one of the reasons cited in the South African case, where the court said it is not the Rome Statute that compels compliance with its provisions, but it is the domestic legislation. So, and there was an implementing act passed by the South African government, and that was what was considered as binding the President to comply with the provisions of the Rome Statute. So, and that is the basis of the distinction between a treaty which is self-executing and a treaty that is not self-executing.
Yes, Your Honor.
A treaty which is not self-executing will have no force in effect until implementing legislation is enacted by Congress.
That is true, Your Honor. However, the Rome Statute, as to take an example, is not such a treaty, Your Honor. There is nothing in the Rome Statute which would require explicitly the enactment of domestic legislation to consider it as having effect within Philippine jurisdiction. So under the treaty clause, the moment that the process of signing, concurrence, and ratification was completed, it acquired the status of law insofar as the Philippine jurisdiction is concerned.
There are provisions in the Rome Statute referring to the implementation of the contracting state by enactment of a national law. So it would seem that there are provisions in the Rome Statute which will require domestic legislation to put them into effect. And as of now, I think it is conceded that we do not have any implementing legislation yet. The IHL was passed before we acceded to the Rome Statute. So the status as of now is that we do not have any domestic legislation implementing the Rome Statute. And so the question is whether or not the Rome Statute is already in force in effect in our country as of this time. And what will be the consequence of this to the power of the President to withdraw from the Rome Statute?
Well, with respect, Your Honor, first of all, that issue was not raised by any of the parties to this particular proceeding. But just for the sake of answering it, Your Honor, it is our position that the Rome Statute, by its own terms, does not require any additional implementing legislation to be considered as binding and enforced in effect within the Philippines, Your Honor. And in fact, Your Honor, we believe that the fact that Congress has in fact allocated during multiple years its prescribed share as a member of the one of the state parties to the ICC. It has enacted the appropriate appropriations to offset our financial obligations is indicative that Congress itself recognizes that the Rome Statute, insofar as the Philippines is concerned, is already in full force and effect here without need for any further domestic implementing legislation.
Okay, that will require an evaluation or analysis of the provisions of the Rome Statute, which is quite long.
Yes, Your Honor.
And the issue of whether implementing legislation is necessary, I think, was raised in the petition of the first petitioners, the first batch of petitioners who argued before the court because they cited the South African decision where the court mentioned that the implementing act of the Rome Statute is the one that is binding on the executive that prevents him from withdrawing from the Rome Statute. There was a passage in the decision in the South African case about an implementing act. So I think we would like to look further into this, whether or not there is a significance in terms of distinguishing a treaty which is self-executing and a treaty which is not self-executing in the light of the absence of an implementing legislation passed by Congress in relation to the Rome Statute. That can be explained in the memorandum of the parties.
We will do so, Your Honor.
Thank you.
Thank you, Your Honor.
That's about all. We lack material time to continue with the oral arguments. For now, we are done with Attorney Gutierrez.
Thank you, Your Honor. Permission to sit down, Your Honor.
Yes, you may take your seat.
Thank you, Your Honor.
So we will reset the oral arguments for the presentation of the Solicitor General. Will it be all right to reset it to September 18? May I ask the parties if they are amenable to, or if they will be available on September 18 for the continuation of the oral arguments.
Tuesday, 2 p.m. That's Tuesday.
May I hear from the parties if they will be available on the 18th of this month?
We will be available on September 18, Your Honor.
Attorney, okay, everyone agreed? So, for lack of material time, we will continue with the oral argument on September 18 at 2 p.m. Thank you. Adjourn the session. Okay na? Oo. Magpapakpok ako.
Please remain standing by the Chief Justice and the Associate Justices leave the session hall.